After wise counsel, I've decided to summarize my judgment. So I'll read a 35-page summary of the judgment, so you don't have to worry that you'll stay here overnight. We will, of course, before the close of business today, have all counsel receive the soft copy in your email, in your respective email. Yeah. Yes, and but before I go into my summary of judgment, I need to read the judgment of Lady Justice Faith Mwanda, who retired and left the services of the Judicial in July last year. But before she left, she perused the draft judgment of the Chief Justice, and she was in total agreement. So I'm reading her concurring judgment, then I go into mine. So this is judgment of Faith Mwanda, Justice of the Supreme Court. I have had the benefit of reading in draft the judgment of my learned brother, Owindolo CJ. I concur with the analysis and the decision made. I also concur with the proposed orders as embodied in his lead judgment. I have nothing useful to add. Signed by Lady Justice Faith Mwanda. So this is the summary of my judgment. Even here I will not read everything, I'll read the core. Part of the summarized judgment. So it headed summary of the judgment of Owindolo CJ. It's not Owinyi, it is Owindolo. Introduction. This appeal arises out of a petition instituted under Article 137, Clause 1 and 3 in the Constitutional Court. In essence, the appeal and cross-appeal are against the majority decision of the learned justices of the Constitutional Court regarding the competence of the military courts, their ability to render a fair hearing, the offenses triable in military courts, and persons subject to the jurisdiction of the military courts in Uganda. The background. When he filed constitutional petition number 45 of 2016 in the Constitutional Court, the respondent was a civilian and member of parliament representing the people of Nakawa Municipality, Kampala Capital City Authority, KCCA, in the 10th Parliament, and a shadow minister for KCCA. He filed the petition against the backdrop of events following his arrest, where he was arraigned before the General Court Martial, GCM, and charged along with others with offenses under the Uganda People's Defense Force (UPDF) Act. To wit, offenses relating to security contrary to Section 130, subsection 1, paragraph F, with the particulars thereof being that he contrived a plot with others to overthrow the government of Uganda, and treachery contrary to Section 129A, with the particulars thereof being that he infiltrated the UPDF or was an agent of a foreign power or any force engaging in war or warlike activities against the government of Uganda. He objected to his trial in the GCM, contending that he was not subject to military law as he had no military connection, and that the GCM was not a competent court under the Constitution to try any of the offenses with which he was charged. But the GCM overruled his objection. He filed a petition in the Constitutional Court challenging the provisions of the UPDF Act number 7 of 2005, which he singled out in the petition, and acts of the UPDF of arresting, detaining, and remanding him to prison in relation to the charges against him as being inconsistent with the Constitution. The proceedings in the GCM against the respondent were stayed by an order of the Constitutional Court. He prayed for a permanent injunction to restrain the appellant from continuing those proceedings. The Constitutional Court partly allowed the appeal in its majority decision, where it inter alia held that as a civilian, the respondent was not subject to military law and could only be lawfully tried by a military court if he were charged under Section 119, subsection 1, paragraph G of the UPDF Act, as an accomplice to a principal who was subject to military law. And the principal was so named in the charge sheet. There being no principal named in the charge sheet, the court held that the charges brought against him were null and void and of no effect. The court also declared Section 119(1)(h) of the Act, which allowed military courts to try persons for offenses provided for under other laws outside the scope of the UPDF Act, unconstitutional. According to the court, Parliament never intended that the UPDF Act should be an act of general application, since it is a statute of special and limited application. Hence, the unlimited and original jurisdiction of the GCM referred to in the UPDF Act only apply to offenses under the Act. Last, the court examined the nature of the military courts and held that first, military courts lack all the tenets of an ordinary court established under Chapter 8 of the Constitution, particularly under Article 28(1). Second, they are tribunals, and third, they are not part of the judiciary. The court accordingly ordered the petitioner to be released forthwith. The appellant was dissatisfied with the decision of the Constitutional Court, hence it appealed to this court. The respondent, for his part, cross-appealed against the decision, allowing civilians in certain cases to be tried in the military courts. The grounds of appeal are: 1, the learned majority justice of the Constitutional Court erred in law in finding that Sections 2 and 179 of the UPDF Act are in contravention of Articles 28(1) and 44C of the 1995 Constitution, and that the GCM is only competent to try military disciplinary offenses under Part 6 of the UPDF Act. 2, the learned majority justice of the Constitutional Court erred in law and fact in determining that the GCM cannot be impartial or independent, is inconsistent with Article 28(1) of the 1995 Constitution of Uganda, and does not apply the principles therein to persons subject to military law. 3, the learned majority justices of the Constitutional Court erred in law and fact in determining that charging and arraigning the petitioner before the GCM was inconsistent with Article 28(1) and 44C of the Constitution. 4, the learned majority justices of the Constitutional Court erred in law in finding that Section 119(1)(h) of the UPDF Act is inconsistent with Article 28(1) and 44C of the Constitution. The appellant prayed that the appeal be allowed, the decisions of the learned majority justices of the Constitutional Court cited be set aside, and the appellant be awarded cost of the appeal. The cross-appeal. The respondent cross-appealed on the following one ground: that the learned majority justices of the Constitutional Court erred in law in holding that a civilian can be charged before military courts as an accomplice together with a person subject to military law. He thus prayed that the cross-appeal be allowed, and part of the decision of the majority justices that he has impugned be set aside or reversed. Consideration and determination of the appeal by this court. The appeal first came up for hearing in this court in 2022. From that time, to its final disposal today. It has suffered an unprecedented affliction by a host of adversities. There is thus an imperative need to clarify on what transpired within that period. The grave and persistent series of events that characterized the lifespan of this appeal began with the fire gutting the chambers of the Chief Justice on the Supreme Court building at Kololo on the 27th April 2022, followed by water flooding parts of the building. This resulted in a condemnation of the Kololo Supreme Court building as being unfit for occupation, thereby leaving the justices of the court with no office accommodation. Thereafter, two justices of the court, namely Justice Paul Mugamba and Justice Ezekiel Mwanguzi, who were part of the original panel for this appeal, retired. This therefore necessitated a reconstitution of the panel. In November 2022, the court was able to secure a temporary home and more justices were appointed to the court. The court then embarked on the process of reconstitution of the panel with a view to sitting by December that year to rehear the appeal. However, that December, we suffered the devastating demise of Honorable Justice Ruby Awere Opio, who had been on the original panel for this appeal. This necessitated awaiting the appointment of additional justices of this court for the requisite reconstitution of the quorum to take place. However, in only 6 months thereafter, yet another tragedy struck this court with the demise of Justice Stella Arach Amoko in June 2023. It was until January 2024 when two more justices were appointed to the Supreme Court, whereafter the court was able to reconstitute the panel for this appeal. The appeal came up before the reconstituted panel on 13th May 2024 in the new Supreme Court building at the Judiciary headquarters, upon which the learned justices reserved judgments to be delivered on notice. Notice has been served on the parties for delivery of the judgment today, and that's why you are here. So the delay in this case did not take 4 years, as some people, including members of the learned profession, have dishonestly been feeding the public. Judgment in this case delayed by 8 months, from May last year to today. If you did some arithmetic at school, you'll find this is 8 months, not 4 years. Yeah. But let me say this also. This is a court of law, court of judicature. The court does not belong to the Chief Justice, does not belong to the justices and judges of the various courts of judicature. It belongs to all of us. It's our property. It belongs to you and me. If you're part of those who bring politics, come to play their politics in this court, you're fighting yourself. You're piercing your own eyes with your fingers, with your nails. Because for as long as you live, you'll need this court. The court you're trying to delegitimize, the court you're throwing mud on, is the one you will run to. That's not to say courts, judicial officers should not be criticized. As a matter of fact, if people do not criticize, it means you're doing nothing, and they ignore you. Criticism makes the best out of a person. But please, what you can do in the political field, and some of us have been there, should be different, whether you're a lay person or you masquerade as a lawyer. Please, this is your home, and for many of you, this is your marketplace. Let us use constructive criticism. Let us engage with the Chief Justice, with the judicial officers, with the administration of the judiciary, so we have a better institution. Each time we improve on it, because this is like a hospital. At some day, you must go to a medical center. So you will come here, your relatives will come here, anyone who seeks justice will come here. So if your purpose is to destroy the judiciary as an institution, it's like democracy. You may not know the worth of democracy until it is taken away from you. It's like the oxygen, the air we breathe. Many times we take air for granted until somebody closes your nose, then you know how important air which we take for granted is. So my appeal is, speaking for myself and then on behalf of the judicial officers, criticize me every day, walk to my chambers and say, Mr. Chief Justice, how can this be? Write to me, because it's not my property. It belongs to all of us. But this idea of thinking that you can gain fame, you want to be known, you learn how to write in social media, thinking you are attacking the Chief Justice, you are attacking yourself. And I ask all these people, please read A Man for All Seasons. You are cutting that forest which you'll need when the devil begins chasing you. So I thought I should say this and then read my judgment. But also let me add, let nobody go fearing that, oh, I have stepped on the foot of the Chief Justice, now he's going to bear ill will against me. No. We as judicial officers, we have taken the type of oath you have not taken. We've taken the oath never to fear. Including never to fear criticism, never to favor, never to be driven by affection, and most importantly, in the circumstance of this case, never to bear ill will against even those who have thrown mud at us, because that is the beauty of being a judge. Meaning, if I can sum up that oath, we must be guided by our conscience. That's really what it is saying. So if you've stepped on my toe, don't fear me. Come to me tomorrow, come to my home. I bear no ill will, and none of the judicial officers bears any ill will. But I also hope that you'll have the courage to say sorry. Some of the things that have come out of members of the learned profession, unthinkable. So learn to say sorry. Just you don't have to say it to me. But some of my judicial officers, please say sorry to them. Because they are doing this for you. The power comes to you, comes to us from you, because you're part of the people of Uganda. So having said that, let me now go into my consideration of the merit of this appeal. This court has been called upon to clarify the constitutionality of several aspects of the law concerning military trials. Even if the arguments gravitate around trials in the General Court Martial, the points raised radiate to the whole military court system. I note that the 4 grounds of appeal and the one in the cross appeal raise cross-cutting issues. And this explains why some submissions by counsel on a particular ground were as well reiterated in other grounds. All the grounds contained an element of counter to the challenge raised against the competence of the General Court Martial and know its status as a court of law. Whereas the standing of the General Court Martial as a court of law was not raised as a separate ground of this appeal, and yet it was a separate question for determination in the Constitutional Court, upon which the court rendered a decision declaring them to be tribunals. It was implicit in all the grounds of appeal that it was an issue. In determining this appeal, therefore, I adopt an integrated approach where a ground may be disposed of in the course of considering another ground. For instance, the status of the General Court Martial as a court has a bearing on the resolution of grounds 3 and 4 which entail the determination of the issues of personal and subject matter jurisdiction of the court respectively. During the period after hearing this appeal, the laws of Uganda were revised. The UPDF Act is now cited as the UPDF Act, Chapter 330, while the impugned sections 2, 119, 1H and G, and 179 have changed to sections 1, 117 G and H, and 177 respectively. However, there is no change in the content. In this appeal, I consider that the issue of the establishment of a court of law, its subject matter or personal jurisdiction, its structure and the fairness of its procedures, and the exercise of judicial power are distinct questions. In that regard, the specific issues for this court to resolve arising out of the Constitutional Court decision, the grounds of appeal and cross-appeal are: 1. Whether the courts-martial are courts of law duly established under the Constitution or are tribunals. 2. Whether the courts-martial can be or are independent and impartial within the meaning of Article 28(1) of the Constitution. 3. Whether civilians can legally, that is without offending the Constitution, be liable to face trial in the courts-martial for disciplinary offenses, hereinafter called military, disciplinary, or service offenses, stipulated in Part 6 of the UPDF Act. 4. Whether civilians can constitutionally or legally be tried in the courts-martial for civil offenses not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislations. 5. Whether it is constitutional for persons subject to military law to be tried in the courts-martial for offenses outside the UPDF Act, hereinafter called civil offenses. 6. Whether it is constitutional for civilians to be tried by the courts-martial as principals for offenses under Section 1191H of the UPDF Act, yet these also exist as civilian offenses. This court is aware of the rules of constitutional interpretation and has set them out in detail. You'll find I've set them out in the main judgment. It is a detailed coverage. Counsel for both parties have, in support of their cases, cited several Ugandan authorities. These include 2nd Lieutenant Ogwang Ambrose against Attorney General, Sergeant Paul Kalemera against Attorney General, and others. Other relevant authorities that have also been delivered since the hearing of this appeal, and upon which counsel in this petition have had no opportunity to submit on, are retired Captain Amon Biarogaba and 169 others. The 2nd Lieutenant Ogwang Ambrose of Uganda, this is another decision for the lieutenant. It that falls on this court to ensure certainty in the application of the law by clearly spelling out the principles that should guide on how to structure and how handle matters concerning discipline in the UPDF. This will ensure that the provisions of Article 209 of the Constitution are given effect to, without affecting other provisions of the Constitution. It will also ensure that the enforcement of the provisions of Chapter 4 of this Constitution. Ground 1 is the General Court-Martial lawfully established as a court of law. Under Part 8, titled Military Courts, the UPDF Act provides for the Summary Trial Authority, STA, Unit Disciplinary Committees, UDC, and Courts-Martial. From the outset, it is clear that the STA and UDC are not established as courts, but as tribunals. The courts-martial established at the Division Court-Martial, established under Section 196, which is now 192, the General Courts-Martial under Section 197, which is now 195, and the Court Martial Appeal Court, established under Section 199, which is now 197, and the Field Court Martial under Section 200, now 198. It is clear that the long title provides that the Act is passed under Article 210 and not 129(1)(d). However, I do not consider that failure to indicate Article 129 instead of 210, as was done in the long title of the UPDF Act alone, is enough to take away Parliament's power given to create a court under Article 129(1)(d). The General Court Martial is part of the courts of judicature referred to under Chapter 8, albeit with a special limited jurisdiction. The other argument for consideration is whether the creation of a court under Article 129(1)(d) requires an amendment of the Constitution and or a referendum. Under Article 259 of the Constitution, an amendment of the Constitution can only be done by an Act of Parliament whose sole purpose is the amendment of the Constitution, and pursuant to the requisite parliamentary procedure for such amendment. I have duly given consideration to the provisions cited, Article 129 that establishes the Court of Judicature, Article 128 that provides for the independence of the judiciary, and Articles 259 and 260 do not stipulate that the creation of a subordinate court per se requires an amendment of the Constitution. Article 129 merely lists the courts of record and provides that the creation of other subordinate courts shall be as established by laws made by Parliament. The UPDF Act is one of those laws, and Section 197(1), now 195(1) thereof, establishes the GCM. It is also evident that the Constitution contemplates the existence of courts martial. See, for instance, Article 257(2)(a) and Article 203(b) of the Constitution. It was contemplated that owing to the unique nature of military work, matters of military discipline should be handled by special courts, court martials in bracket, and military tribunals, UDCs and STAs. The issue whether the General Court Martial is a court was conclusively settled in Attorney General against Tumushabe and Attorney General against Uganda Law Society. It would, however, do well if Parliament clearly stipulates in the law enacted the status of a court created as the Magistrates Court Act does. I note that in Attorney General against Tumushabe, this court came to the conclusion that since the GCM exercised judicial power, it is or must be deemed to be a court. To the contrary, my finding is that the legality of the establishment of the General Court Martial, not based on its exercise of judicial power, but on the authority conferred on Parliament under Article 129(1)(d) of the Constitution. Exercise of judicial power and tribunals. Before I take leave of this issue, I would like to address myself to the aspect of the exercise of judicial power by courts and military tribunals, upon which the learned justices of appeal based their decision in retired Captain Amon Biarugava. As a general rule, in a democratic society or dispensation, every aspect of judicial power must be exercised by a competent authority established by law. Judicial power, which is exercised by the judicial arm of government as an institution, as is provided for in the Constitution, refers to the authority vested in the courts of judicature, whose judicial officers interpret and apply the law, resolve disputes, and administer justice generally. In a narrower sense, Judicial power generally uniquely involves an exercise of power to interfere with the personal liberty of persons who appear before it. And this usually falls exclusively within the realm of ordinary courts of law, although there is no express bar to criminal exercise of jurisdiction by some tribunals. Tribunals usually exercise quasi-judicial power as opposed to judicial power of the courts. As a characteristic, the moment an entity can hear criminal cases and give custodial sentences or detain its suspect during hearing, the entity exercises judicial power regardless of its title as a court or tribunal. In other words, the exercise of judicial power is not in all cases what differentiates a court from a tribunal. I have noted that under the UPDF Act, the UDCs and STAs, UDC is Unit Disciplinary Committee in case you had forgotten, and STA is the Summary Trials Authority, that are established as tribunals have been given jurisdiction to try offenses, and sentences that they can impose range from caution to custodial sentence. Pursuant to Articles 23, 126.1 and 129.1 of the Constitution, it is only the courts that are granted the mandate to interfere with personal liberty in the sense of custodial sentences, or any legal detention of a suspect for an extended period of time during a hearing. Therefore, in the Ugandan framework of military courts, it is only the courts martial that are established as courts of law under the Constitution that can properly or legally be said to exercise judicial power when hearing offenses, criminal or disciplinary, with the power to impose custodial sentences and detain suspects. The UDCs and STAs are tribunals. Hence, whatever judicial powers they exercise are unconstitutional, as they do so without lawful authority. Ground number 2. Every court established under the Constitution must meet the criteria for a fair hearing. Similarly, tribunals entrusted with judicial power have to apply the principle that ensure a fair hearing, and for this, the classification as courts or tribunals bears no relevance. The right to a fair hearing is one of the fundamental human rights that are considered an imperative in any trial. See Article 28.1 of the Constitution of Uganda as amended. The UDHR, Article 10 of the UDHR, Article 14, Paragraph 1 of the ICCPR, Article 7 of the African Charter. The guarantees of the right to a fair trial applies to all courts and tribunals, including military and other specialized courts. The principle of equality. Judicial power, even though it is limited in jurisdiction, has been devolved to military courts to be exercised in line with the Constitution, while respecting the fundamental rights and freedoms of individuals appearing before them. It goes without saying, therefore, that all persons, including military personnel or persons subject to military law, are entitled to the non-derogable right to a fair hearing. Although a soldier becomes subject to the military system, he does not cease to be a citizen, and his rights as a citizen remain relevant, albeit in an amended form. But whatever legislation is applicable, it must still be interpreted in light of the supreme law. Can a military court be independent, fair, and impartial? A military court can be independent, fair, and impartial. Thus, trial of a person by courts martial does not per se occasion a violation of the person's right to a fair hearing provided for under Article 28.1 of the Constitution. That provision does not specify the composition of or procedure adopted by such a court or tribunal, other than listing the procedural safeguards required for a fair hearing. However, as noted earlier, Article 128 of the Constitution also imposes a requirement as to objective independence of the court or tribunals exercising judicial power as a safeguard to a fair hearing. Proof. An individual who challenges the independence of a tribunal need not prove an actual lack of independence. See the case of General Oaks. In a particular case, the challenge can touch on the whole structure and procedure of the courts. Similarly, this is an objection to the system of trial within the General Court Martial in its current structure. Test for independence and impartiality. What may be considered to pass the test for independence and impartiality and thus ensure a fair hearing in military courts has been a subject of wide consideration and discourse. With regard to independence, Article 128(1) of the Constitution provides that, quote, in the exercise of judicial power, the courts shall be independent and shall not be subject to the control or direction of any person or authority, close quote. Article 128, clauses 2 to 8 are all provisions geared towards ensuring and maintaining this independence. To determine whether the courts martial or the persons manning the courts are independent in the exercise of their judicial powers requires an examination of the laws and procedure under which the courts operate. From this, one can then determine whether a reasonable person familiar with the Constitution, the laws setting up the military courts and their structure would perceive and be satisfied that these courts are independent. Counsel for the appellant emphasized that fairness in the General Court Martial is assured because the members of the General Court Martial take an oath to uphold the Constitution and administer justice. Indeed, it is the norm that judicial officers take an oath to render justice, and this places the duty on the respective judicial officers to exercise the judicial power with independence of mind and impartiality. However, this subjective undertaking of exercise of duty is only truly guaranteed when it operates alongside the objective safeguards that can satisfy a reasonable person that the appearance of partiality is eradicated, and the judicial officer is acting with an independent mind and is insulated from extraneous factors such as an undue influence. Impartiality is determined by the absence of bias, objective or perceived. In this regard, objective impartiality is akin to independence. The test for impartiality is, open quote, whether a reasonable, objective, and informed person acting on the correct facts will reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of cases, close quote. C, in re an application for recusal of Honorable Justice Alphonse Chigamoyo Windolo, Chief Justice, miscellaneous application number 3 of 2021, arising from presidential election petition number 1 of 2021, Chagulanyi Sentamu Robert against Yoweri Kaguta Museveni Tibuaburwa, and two others. It is clear that in impartiality, appearances are of importance in order to satisfy the subjective requirements. See also the case of R against Spear and Findlay against UK. In the instant case before this court, the respondent makes no allegation that the members of the tribunal were actually biased. I would thus recast the issue of independence, impartiality, and impartiality of the members of the court as follows. Whether a fair-minded and informed observer would conclude that the safeguards for a fair hearing in the court-martial were adequate to guarantee the independence and impartiality of members of the court-martial. What is manifest from an examination of our laws is that, with regard to courts-martial, 1, with the exception of the CMAC, court-martial appeal court, there is no legal requirement for a person qualified in law to form part of the quorum. Before I proceed, I wanted to understand that apart from the court-martial appeal court, the others who sit and carry out judicial function, there's no requirement for them to study law, to be lawyers. So it's like there's no requirement for anyone to go to a theater and operate on a patient. You can pick the most famous lawyer in town and give him those knives, I don't know how they call them. Or you can pick the Chief Justice of Uganda, give him 12 people, not even all 12 people. He would have been carrying the rank of a corporal in charge of a section, and you place him at the board of DRC to protect Uganda against possible enemies. He has never touched the trigger of a gun in life. He doesn't know map reading. He doesn't know how to win civilians to his side. He did not have the 9 months training that is required, the basic training that makes you be a soldier and get the first rank of private, I think the first rank of recruit. Or you ask any professor from Makerere University, say, look, we are giving you a Boeing 074, you fly it to Addis Ababa. These are not jokes. Yeah. The importance of professional training to be able to do something. Order in the court. The importance of professional training to be able. And in this, nobody is saying, even the respondent, when he brought the petition, he's not saying Major so-and-so or Colonel so-and-so was biased. He's not saying that. Or that he's just saying, look, these people do not have the training to be judicial officers. They try treason, they try all sorts of things. But when the LC Courts Act, the law that placed the LC Courts, because they knew that the LCs were not trained in the law, they were not given jurisdiction over criminal matters. Not even theft of chicken, by the way. They were not given jurisdiction. So the first one is legal training. 2, the judge advocate's role is entirely advisory, as he or she does not form part of the court that deliberates on the verdict and sentence. So the judge advocate acts like an assessor whose view does not bind anyone. 3, decisions are by majority opinion of members of the court. The courts are convened and the members are appointed by the High Command or some other authority delegated by the High Command. Not appointed by an independent institution. The commanding officer of the brigade probably would appoint who sits in the divisional court-martial. The courts comprise military men with no differentiation as to whether they are active, about to retire, or have retired. Junior members and a political commissar form part of the quorum. You are a major and a private can sit in the body that tries you. No right of appeal is created to the ordinary courts under the Act. The appeal ends with the court-martial appeal court. Unit disciplinary committees and the summary trials authorities exercise judicial power under the law as they have jurisdiction to pass custodial sentences and thus infringing on the liberty guaranteed under Article 23 of the Constitution. With the benefit of various authorities and instruments enunciating the law on the issue of independence and impartiality of courts-martial, I have examined the structure and procedure of the courts-martial in Uganda to assess how they fare in this regard. I have found as follows: A, legal qualification. Currently, the General Court-Martial, Division Court-Martial, and even the UDCs and STS as tribunals exercising judicial power have no legally qualified personnel on their quorum. Yet their jurisdiction is not limited only to disciplinary breaches, but extends to crimes or offenses that are also triable by the civil courts. This includes serious offenses that attract custodial sentence of over 6 months and the death penalty as well. These untrained persons can issue decisions on questions of law and fact. Go back to the example I gave. You take me to the theater in Morago. I will not know the difference between a kidney and the liver. Yes, that's the truth of the matter. And I'm fairly educated, as you know. Or put me as a brigade commander. Everybody will flee from the area knowing that there is no security. The decision of the judge advocate in the court-martial appeal court, who in any case is not a full member of the court, is merely advisory, as I've said, as it is not binding on the panel. The absence of legally trained personnel in the exercise of judicial power in the general court-martial and the other military courts or tribunals is at variance with the situation obtaining in the civil courts. This presents two parallel and contrasting standards in the administration of justice. The civil courts are competent as they meet the standards laid down in the Constitution, while the courts martial function in sharp converse thereto, and this is inimical to the right to a fair hearing before an independent and impartial court. Hence, it adversely discriminates against persons who appear before the courts martial. The consequence of this is that it renders the functioning of the court martials unconstitutional. B, composition of the court by military personnel. This issue gives rise to two distinct questions. First, whether a parallel system of military courts or tribunals staffed by members of the military who are aware of and sensitive to military concerns by its very nature, inconsistent with Articles 28(1) of the Constitution. Second, if the answer to the first question is in the positive, whether that is the end of the matter. However, if it is in the negative, then the next question is whether the General Court-Martial, as constituted at the time the respondent was charged under the UPDF Act and regulations made thereunder, is an independent court for the purpose of Article 28(1). I find that the presence of military personnel as members of the courts martial is not by itself evidence of the court's lack of independence and impartiality. However, when viewed by an objective, reasonable person, there is a difference between active servicemen under the chain of command and former servicemen who are in retirement or about to retire and are therefore not influenced by any hope for promotions. Active servicemen are under the chain of command and may be influenced through the chain of command. Furthermore, the oath taken by the members of a military court under Rule 27 of the UPDF Rules of Procedure Regulations binds them to the High Command and convener of the military courts. This stands in stark contrast with the judicial oath in the Oaths Act, Chapter 19. This, taken together with the non-inclusion of a legally qualified judge on the panel to rule on legal issues, denies the courts martial the independence and impartiality which would have clothed them with competence. The other judicial oath, you swear to protect the Constitution. In the military, you swear to protect the commander-in-chief, the other officers. That's the difference. That's the difference which comes out. Well, that's the law that Parliament passed anyway, yeah. C, manner of appointment of its members. There is the military personnel sitting on a tribunal that handles purely disciplinary matters and only imposes such punishment as reprimand, demotion, dismissal, compensation on the one hand, and military personnel sitting in a court which has the competence to try persons for crimes which attract such penalties such as custodial sentence or even the death sentence. I am of the opinion that there is a need to distinguish between the two in determining the issues concerning the courts martial. First, the appointment to the service disciplinary organs is normally limited to administrative matters, whereby the fact of the presiding officers being subject to the chain of command does not occasion any miscarriage of justice. Unlike with the appointment to the courts martial, handling substantive judicial matters where it could occasion injustice. The appointment of an officer on the courts martial by the President or High Command might not necessarily suffice to deprive the court of the requisite independence for the exercise of judicial power. However, this must be taken together with the provisions for other safeguards for the promotion and guarantee of the independence of the courts martial, and then determine the effect of such appointment on the independence and impartiality of the members of the court. The provisions for the appointment of personnel on courts martial must be in conformity with the provisions for appointments of judicial officers in the civil courts and ensure competent persons sit in all courts. D, term of office, that is security of tenure. This relates to the terms of appointment of the members of the court, including the judge advocate. The appointment of members of the courts martial is by the High Command and for a period of 1 year only, though eligible for reappointment. There are also waiting members who are appointed and can be called upon to sit in court as and when needed to realize quorum. See Regulation 21 and 23 of the UPDF Act Rules of Procedure Regulations. The fact that a member of the court is appointed only for a short period of time and on an ad hoc basis means that such a person may have no cushion against external influence by the one who appoints him or convenes the court. They do not have protections of security of tenure available to civil judges in Article 128 of the Constitution. I therefore reach the conclusion that the provisions of the law governing the courts martial do not guarantee their independence or impartiality. E, convening authority and prosecuting authority. The convening authority performs an important role in the court martial judicial process because the laws grants it the dual role of the court and that of the DPP. Under the powers conferred on it by Regulation 21, this authority, among other things, determines the charges to be preferred, appoints the prosecutor, issues a convening order, determines the time of trial, and procures attendance of the witnesses. It has been held in other jurisdictions, in criminal prosecutions, it is an imperative that the convening authority lies with court, which enjoys guarantee of institutional independence from the body prosecuting cases in court. However, with regard to the courts martial, the situation is wholly different. The military appoints the convener of the court from within its ranks, and similarly does so for the prosecutor of the court. It also appoints officers who are under its command to preside over the court, but accords them no security of tenure in the exercise of their function as members of the court. This situation does not portray or manifest an impartial and independent court. Accordingly then, its constitution and exercise of judicial function is unconstitutional, as it violates Article 28(1) and 44(c) of the Constitution. F. Existence of other guarantees against outside pressures, also known as objective impartiality. Most of the determinants of independence and impartiality of courts have been institutional. The other aspect of fair hearing is the legal procedure available to a suspect who appears before the GCM. Procedures of fair trial are to be observed by all courts and tribunals that are an integral part of the judicial system. No adherence to a fair hearing has a double-edged effect. The obvious one is the denial of an accused person the right of due process. The other may have an adverse effect on this, as some accused person may also escape punishment under the guise that they were not given fair hearing.